Good morning, everyone. We had started the topic of the fundamental duty, and in context of fundamental duty, we'd seen that but we had not gone into the criticism of the fundamental duty as well as the question which I was talking about, that rights and duties के context में we may get a question. We had seen certain acts which were enforcing the fundamental duty. Right. We'd seen that there are certain fundamental duties which are already enforced through an act. देखिए, don't think that fundamental duties are enforced. However, because these are not enforceable. However, there are certain acts which are actually enforcing what is said in fundamental duty. So, fundamental duties are not enforced, but there are acts which are enforcing certain points which are discussed here. That is what we had seen last time. That is respect. Let's say if you disrespect the national anthem and the national flag. Now here national song is not there. Okay, so if in the question or in the comma it comes as national song, so you will remove that. But national flag, national anthem. So Prevention of Insults to National Honor Act. We had seen that if you work against the unity and integrity of the country, then also there would be issue. We find that if somebody promotes disharmony, that is also we've got issue. If we talk about, let's say, anything, if somebody gives statement which are derogatory to the dignity of women, then action could also be taken against that person. When we talk about heritage, in this sense, we find that we've got Ancient Monument and Archaeological Sites Act 1958. So, if somebody demolishes or destroys or do something negative to the monument, they can also be punished. In terms of environment, we've got Environmental Protection Act (NGT). We've got n number of let's say cases which can also be used. Even the FRA, that is Forest Right Act, उसमें भी there are few things which speak about protecting the forest also, because when the rights are given to the tribals, at the same time it should not be detrimental to the forest. So there are many things we had seen before we had gone for the break. Now when you talk about the fundamental duty, you give a heading, new heading, criticism of fundamental duty. Give heading, criticism of fundamental duty. ठीक है, देखिए, in terms of criticism of fundamental duty, we find that one of the strongest criticism, it is non-enforceable, and it should have been enforced. Swaran Singh had actually recommended that there should be penalty if people are not following it. There's another criticism that these are not exhaustive. When we say not exhaustive, it means more fundamental duties should be there. Jैसे to pay taxes, to resist injustice, means these 11 are pretty less. We need to have more. However, wherever we have fundamental duty, there is a view that duty should be of the state, not of the citizen, and the state is trying to be master of the citizen. That is also a criticism. When we look at the articles which I had explained to you, that was 51 capital A small b f h j, that terms are not pretty clear, and this would make the enforcement more arbitrary, or the state would get more power. BFHJ, if we look into that, that is noble ideals, I had told you, so we are not sure what ideals they are trying to talk about. We've seen a rich heritage of our composite culture. What do you mean by composite culture? We're not clear. Scientific temper. So, not sure. What do you mean by scientific temper in terms of practicality when we would like to implement it? So, that is also, we've got an issue. And strive towards excellence. So now all these things are relative also, let's say excellence. So there could be a question in mains which talks about fundamental duty to be enforced. However, at the same time, it may also talk about critical evaluation of fundamental duty, and there we find that you have to mention criticism, right? So depending how the question is drafted, you will accordingly write the answer. Point में लिखिए, write down point पे criticism of fundamental duty, write down non-justiciable. First point is non-justiciable. Within the bracket write down Swaran Singh recommended penalty. Swaran Singh recommended penalty. ठीक है? It means that Swaran Singh wanted it to be enforced. ठीक है? So all this can also come as a statement that Swaran Singh had recommended that it should be enforced. Right, next point. Should have been added in part 3. Should have been added in part 3. Okay, part 3. Now, part 3 is fundamental rights. So that if we added in part 3, so the value of the fundamental duty would have been more. That is why it was said that should have been added in part 3. Okay. We know it, fundamental duties, fundamental rights are in part 3, right? Next point. Next point is are not exhaustive. Are not exhaustive. Are not exhaustive. Within the bracket write down. Within the bracket write down. Swaran Singh committee. Yeah, Swaran Singh recommended paying taxes. Swaran Singh recommended paying taxes also as a duty. Swaran Singh recommended paying taxes also as a duty. Next point. Complicated terminology, complicated terms, complicated terms. Right? Example, noble ideals. Example, noble ideals. Composite culture. एक और example लिख लो, composite culture. Another is scientific temper. Scientific temper. ठीक है? So these are terminologies which are not pretty clear. Next point is enforcement may make. Next point is enforcement may make state. Enforcement may make state arbitrary. Enforcement may make state arbitrary and authoritative. Arbitrary and authoritative. Full stop. Continue. As it does not convey. As it does not convey any definitive ideas, as it does not convey any definitive ideas, any definitive ideas. ठीक है? Within the bracket you can write BFHJ. You should know that these particular articles or the article 51 capital A small b f h j. Now these things are not clear. ठीक है? Write down the next point. Next point will लिखिए. State is trying to be. State is trying to be master of citizens. State is trying to be master of citizens. Next point. Timing of introduction. Next point is timing of introduction is questioned. Timing of introduction is questioned. See, in terms of timing, why it is questioned? Because it was introduced in 1976 and that was at the time of emergency. So, a lot of time it's questioned that this was brought in during emergency, so this feature should go. However, we would be able to defend this point also. Give a gap of 1-2 line, so it's a different context. Give a gap of 1-2 line, so we are out of the criticism. Okay? After 1-2 line, write down performance of fundamental duty. Performance of fundamental duty would be automatic in performance of fundamental duty would be automatic in nature if the citizens are vested, if the citizens are vested, vested, if citizens are vested, vested with high citizenship values, if citizens are vested with high citizenship values. Okay. So instead of making it enforceable, you could also have this view that if we, let's say, if we inculcate the citizenship values, then automatically the performance would be there. You will notice earlier the old NCRTs, I'm talking about before 2000, so the new, now we'll have another new NCRTs also. However, the NCRTs of this century would have more of duties mentioned at different places. It would also talk about rights, but earlier the old NCRTs used to talk about fundamental duty only in the place in polity where it was being discussed, let's say 51A. However, now in, let's say, even before index, it could be mentioned in different classes. It is mentioned. Gandhi's talisman is mentioned. So, what happens is in these texts, you will find that it is trying to inculcate citizenship values. It is telling you about that's what citizens should do. So it is trying to build up those value system. So even if you don't enforce the fundamental duties, it would already be enforced because citizens would be following the ideals, because once they are proud of being the citizen of the country, they themselves would not do anything which would be detrimental. Okay. Now, another heading is, write down another heading, uh, does it hold significance? Does it hold significance? Right, how we had done for DPSP, that is DPSP holding any significance, same thing could be asked here also, that is it holding any significance? So for DPSP we could defend that easily. Likewise, fundamental duty pe bhi question may come, that is it holding any significance or should it be removed? Because there is a question that it was introduced in emergency, right? Now, in terms of the significance, if you see, like DPSP, we said that DPSP is now much more significant than what it was. It was significant at that time. It is even significant. It was significant even in the last century, and it is now much more significant. And we defended that. Same line we would take in this context also, that fundamental duties were important and now it's also important, and comparatively it is now more important. And how we'll defend that? Basically, uh, we've got corruption is increasing, crimes against women are increasing, environmental issues are increasing, moral compass or the citizens are not, everybody is talking about himself or herself, not about the community as a whole. So in this case, the socio-economic disgust is there that condition-wise there is no bonding. But see, when I'm saying there is no bonding, now don't think that I see bonding. This is how we see that people are helping each other. See, we're trying to understand it from the context of the whole country. We find that the country is more divided on maybe caste lines or religions line, state lines, and the identity of oneness. Now, oneness with diversity we need to have. Oneness does not mean we should not be proud of our state. A person can be proud of the state as well as proud of being a citizen also, right? So don't think that patriotism cannot be practiced at different level. Patriotism can be practiced at different level. So you could be proud of your gully, you could be proud of your district, you could be proud of the state, and you could be proud of the country also. Everyone takes care of their district. Let's say they're making sure that nothing wrong or no wrong actions are taken in their, maybe in their area, in their gully, or maybe in their where they are living, maybe the society. Everybody works on those lines. So wherever they're staying, they'll make sure that nothing wrong happens in the society. So what would happen? The city will develop. If all cities develop, the state would develop. If all the state develops, then the country would develop, right? So we find that fundamental duties are comparatively now more important also. 42nd constitutional amendment had introduced a lot of things. Now in terms of the introduction, a lot of things were also taken back or taken out. 44th constitutional amendment removed a lot of things. We've seen that in the last so many hours. We've seen this was removed by 44th, or this was added by 42nd. Finally, what do we get? We get that even though fundamental duties were introduced by 42nd constitutional amendment, but 44th constitutional amendment did not remove it. What message does it send? It is clear that the other political parties also accepted and agreed that fundamental duties are very important. Otherwise, they would have removed it. Why they did not remove it? They could have said that, okay, we are removing fundamental duties also, but they did not touch it. It means there was a consensus that fundamental duties should be there. Otherwise, we could have removed it, right? So even if the timing of the introduction is questioned, this could easily be countered that why it was not removed, because it is important. Also, in terms of the let's say importance, we find that there was Verma committee. Verma committee, on the contrary, actually, instead of talking about removing the fundamental duties, spoke about increasing fundamental duties, like resist injustice. A national commission to review the working of the constitution even said that please recommend the NCRWC actually said implement the recommendations of the Verma committee. It means that not only these 10, 11, they wanted to have more fundamental duties. So how can we say that fundamental duties are not important? It is important. We want to increase it. Getting my point? So this is how in mains you will be defending that fundamental duties are even important in the contemporary period. And whatever you means 51A is like, we've got, see, crimes against states are increasing. So we need to have enforcement of the fundamental duty. Crimes against women are increasing. Again, the same fundamental duties should come into the picture, right? So there are a lot of things we can easily defend if we understand the fundamental duty properly. Also, unlike PT, in mains, fundamental duties does not come in, let's say, individual statement wise. It would be somewhere how we understood the DPSP. Holistic form it should come. That is what we're trying to do. Write down, does it hold significance? That is what the discussion is. Write down. The heading is, does it hold significance? Write down, the current conjuncture conjuncture, conjuncture, the current conjuncture, conjuncture, the current conjuncture of socio-economic forces, and disgust, DISGUST, and disgust, 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 sorry, and disgust aroused, AROUSED, aroused by falling, by sorry, by falling ethical standards, by falling ethical standards, by falling ethical standard, provide a timely opportunity, provide a timely opportunity to launch a nationwide movement, to launch a nationwide movement to enable all citizens, to enable all citizens to become aware of their rights, to become aware of their rights and responsibilities, rights and responsibilities, comma, understand their obligations, understand their obligations to observe constitutional values, to observe constitutional values and carry out fundamental duty, and carry out fundamental duty in day-to-day activity, in day-to-day activity. Next line. Even the 44th Constitutional Amendment Act, even the 44th Constitutional Amendment Act 1978, even the 44th Constitutional Amendment Act 1978 made lot of changes, which were introduced by 42nd Constitutional Amendment, which were introduced by 42nd Constitutional Amendment, which were introduced by 42nd Constitutional Amendment, but did not change the fundamental duty, shows that its significance was understood, by all political parties, Next line. NCRWC, that is National Commission to Review the Working of the Constitution, NCRWC suggested National Commission to Review the Working of the Constitution, NCRWC suggested to popularize fundamental duty, and to implement the recommendations, and to implement the recommendations of Verma Committee. Recommendation of Verma Committee. Example, resist injustice. Resist injustice. So basically, Verma Committee had said that there should be fundamental duty to resist injustice also. Now, with this, we see we would be easily be able to defend the let's say fundamental duties in terms of its significance. However, you will pick up more points from, let's say, crimes increase against women, caste violence is increasing, environmental issues are increasing, and you will be incorporating it. So you will have a beautiful 250-word answer. You can actually write essay also. Then you will give more weightage to every single maybe area, right? Now let me see the questions. We've got Article 13 clearly says that any law inconsistent with fundamental right will be declared as null and void. But we learn that there are many laws, family laws, which violate fundamental rights. Then how these laws are surviving? Why they are not following constitutional provision? Beta, they are following the constitutional provision. ऐसा कुछ नहीं है that they are not following constitutional provision. Let me show it to you. Okay? The question is raised, that is, no law which is violative of fundamental right can continue. So why family laws are continuing, right? Now in this context, एक minute. This all laws in force, this particular domain जो है ना, under this category, Article 13 is saying what? All laws in force cannot be in violation of the fundamental rights. This category, all laws in force, does not include personal laws. That is what the Bombay High Court has said, that the personal laws are not laws in force. This was given in Narasu Appa Mali. Appa is different word, Mali is different. Narasu Appa Mali case. So because of the Narasu Appa Mali case, now this is not a Supreme Court judgment, this is a High Court judgment. However, this was never challenged. So a lot of time, whenever there is an issue regarding the personal laws, it is always said that the ghost of Narasu Appa Mali case is coming back. This is where the problem is. So personal laws are not tested with Article 13, means not filtered. Article 13 is a filter. Personal laws are not filtered. Now because it is not being filtered, so it does not it's not tested in context of fundamental right. However, post the independence, if a law is made, those would be tested through fundamental rights. So slowly we see that even laws which are there जैसे pre the constitution, even they are also being tested, but depends on case by case. I hope you got the point. Because of Narasu Appa Mali case, it is said personal laws are not laws in force. That is where the issue is. Okay? Now, let me see another question. So in Goa Civil Code, provision related to Gentile Hindu women is a clear-cut violation of Article 14. It's a pre-constitutional. Then why doctrine of eclipse was not applied over it? बेटा personal laws, civil laws, personal मतलब personal laws are not laws in force. That is why it is not applied there. That is what the issue is. So I hope you got the point that why this issue is there. So it's for the exam. You should know that personal laws are not laws in force. That's it. And you have your answer. Okay? Now, before we means the last heading we need to discuss in context of fundamental duty is the rights and duties. Rights and duty. Now, in terms of rights and duties, when we look into this, overall is I personally feel the question in mains may come from this side because I've told you earlier also the Prime Minister has been promoting the duties in terms of in many of his messages, including the message which was given on 26th January this year. Again, this is a part of mains that what let's say how do we compare rights and duties. So I would even give you the answer so that if I answer means that if at all 250 word question comes, you means in terms of when you need to answer it in so many words, you should be able to answer. Now in terms of rights versus duties, when we look at that, rights are actually flowing from duties. Without right or without duty, there is no right. Because imagine that somebody is not following his duty. If the person does not follow his duty, then the right of the other person also would be infringed. If a person does not respect the right of others, it means he is not following his duty. So rights and duties would always coexist, even if you don't mention duties. It has to be there. Right to life, let's say Article 21, now that's a right. But if somebody does not follow his duty, then the right of other person would be getting impacted. But freedom of speech and expression, that's also a right of a person. But if the other person stops this person from speaking, it means the other person is not doing his duty. So rights are integral parts of duty, and even if you don't mention any of the duty, still duties exist. What we need to understand is, we need to understand it in the context. Jesse, let me show it to you. When we talk about to defend the country and render national service when called upon to do so, and if we look at 23(2), 23 clause 2 talks about that state may impose compulsory service. So 51 capital A small d is going very well with 23 clause 2. So the point is fundamental duty and fundamental rights may, even if you don't mention any of the duties, you will still have the duties. Okay? So there are two different things, but they both are one thing only. That even if you don't mention duties, still duties would be there. देखिए, we've got Ramlila Maidan case, we've got Javed versus State of Haryana. Now, in terms of Ramlila Maidan case, what had happened? India against corruption, the protest movement was at its peak, and let's say Baba Ramdev wanted to conduct a yoga session there, but the government was thinking that he may use this forum for political reasons, so they were not giving him permission. He gave a written, let's say, assurance that I will not use this platform for any political aspect, only yoga, for yoga I'll use it. Permission was given. Later on, he started using this platform to for political reasons also. So at night when everybody was sleeping, there was also lathi charge which was done. Now that was very, I mean, that was a sad incident, that on lathi charge was done on people who were even sleeping. So this issue went till Supreme Court. Supreme Court did reprimand or did use strong terminology for the police. However, they had also said that citizens should also, when they're talking about rights, they should also look at the duties of the citizens, right? Fundamental duty. It means that if you're answering a question related to fundamental duty, you have to introduce maybe Ramlila Maidan case. Now that's in context of rights and duties, if at all it is there. See, it's not that our constitution makers or the Constituent Assembly forgot to introduce duties. When fundamental duties were introduced in 76 in the Parliament, it was said that it was a historic mistake. However, you will not say that the fundamental duties were introduced later on because of the mistake of the Constituent Assembly. No. You will say that the Constituent Assembly, they were sure that these things are very much present in the Indian way of, let's say, Indian system. Ahimsa, abjure violence, it's present in the system. Respect the elderly, that's also present in the system. Right, loving towards the land, that's there in the Indian system. So all the duties which were mentioned were part of the Indian system, and the Constituent Assembly believed that the people, because of the Indian system, people would follow all these things. So it was not introduced purposely. However, we find that the moral compass also sometimes goes down, and with the aspects, earlier we used to believe that people should, or nobody should do anything wrong, or I would not do anything wrong because the Almighty is looking at me. Now this feeling is going down. So we need to have something like duties, we need to have more laws, so that the Indianness or the concept of duties also continues. So don't think the duties were the वैसे देखा जाए, if you look at it, that the fundamental duty as a concept were not being introduced itself, but there was no discussion on this particular issue, that should we have fundamental duties or not in detail. But when it was introduced later on, it was said that it was a mistake because of which we could not introduce it. However, you will not say it was a mistake. You will say that right flows from duties. The main, and what we need to do is to understand the concept. If you understand the right properly, you will see that duties also are there. Write down आप statement लिखिए आप. Heading is rights and duty. Write down. Real rights are result of performance of duty. Real rights are a result of performance of duty. Next line. The true source of right is duty. The true source of right is duty. Next line. Duty is an inalienable part. Duty is an inalienable part of right. Duty is an inalienable part of right. ठीक है? Now, give a gap of one line and then write down In Javed versus State of Haryana, in Javed versus State of Haryana, the Supreme Court said, in Javed versus State of Haryana, the Supreme Court said that fundamental rights are not to be read, fundamental rights are not to be read, FRs are not to be read in isolation, not to be read in isolation. They have to be read, they have to be read, they have to be read along with, they have to be read along with DPSP, they have to be read along with DPSP and fundamental duty. They have to be read along with DPSP and fundamental duty. Next line, in Ramlila Maidan case, look at Judge versus State of Haryana, this is 2003 and this is 2012. So in Ramlila Maidan case, the court said there has to be a balance, and proportionality, there has to be a balance and proportionality between the right and restriction, on one hand, right and restriction on one hand, and the right and duty, on the other, full stop, continue. It will create an imbalance, comma, if undue or disproportionate emphasis is placed upon the rights, RIGHTS, rights of a citizen, without considering the significance of duty, Next line, in order to enjoy rights, one must accept duties. Full stop, continue. Rights and duties coexist. Full stop, continue. As the rights and duties are correlative, the fundamental duty are therefore intended to serve, as a constant reminder, as a constant reminder to every citizen, that while the Constitution specifically conferred on them certain fundamental rights, comma, it also requires citizens, to observe certain basic norms, certain basic norms of democratic conduct, and democratic behavior, Next line, it is the obligation of the state, to educate the citizens, in the matter of fundamental duty, so that right balance between rights, RIGHTS, right balance between rights and duties, may emerge. Right. So in this context, you know that there is, look into Article 51 capital A small d and 23 clause 2. You will find there is a linkage. You can actually even look into 23 clause 1 also, and let me show it to you. 23 clause 1 talks about that forced labor should not be there, so it means kind of fraternity if it is there. So that would also make sure that these forms of, let's say, begar or forced labor is not there. Another is compulsory service. 23 clause 1, 23 clause 2, right? That is what I have written, 23 clause 1, 23 clause 2. And to show you the linkage, let me take you to the fundamental duty. Twenty-three clause 2 is compulsory service, and here you see defend the country and render national service. 15 capital A small d, and I had taken you to even the E aspect also, that is 15 capital A small e. Here we find that they talk about forced labor should not be there, so to promote harmony and spirit of common brotherhood. So that is also a part, or means what we need to understand is that rights are flowing from the duties. The basic aspect is to understand the concept and how it is happening. So you can use this as your answer also, means example also. Now, sir, can we say in terms of definition of Indian citizen is who follows fundamental duties, those people are Indian citizen? Not necessarily, beta, because see, duties are not enforceable. So just as somebody is not following duty, we can't say the person is not Indian. If a person is not following a law which is enforceable, then a person is still punished, but again the citizenship is not coming in question. So there are many rules, and just by not following a rule doesn't make that person is not a citizen. Getting my point? देखिए, let's say person goes into a fight, some fight is happening between people. That does not mean the person is, let's say in terms of citizenship should be in question, though person should be punished. If somebody gives, let's say comments which are derogatory to dignity of women, the person should be punished. But in terms of citizenship, it nowhere comes in the question. So there are different issues when citizenship should come in question. That is, there are certain different things. If somebody joins the enemy state in terms of, see, even going into an enemy country wherein we are having some war, why the person is going into that country at all? But the point is, if somebody is giving secret information to any country, that is where is that the person is betraying the country. Somebody leaving the citizenship and going into another country, there is no problem. But somebody giving the information which would be detrimental to the country's safety, security, sovereignty, that is where means even at that context we find that there are strong punishments. However, citizenship is in general not taken out even in that context. ठीक है? So we've seen fundamental right, we've seen we have seen DPSP, we've seen fundamental duty also. Before we go ahead, we'll do certain questions also of the judiciary. I told you that you will, uh, एक minute. I told you that you will prepare also. So we've got, I'll show you the options at the later end. Means firstly I want you to answer without the options, and so that reduction method is not applied. Then I'll show you the options. Okay? So according to Article 143, which of the following statements are related to advisory jurisdiction of Supreme Court? ठीक है. Now we've got the Supreme Court must tender its opinion to the President on any question of law or fact of public importance which has arisen or which is likely to arise. The first statement is wrong. Now, second statement. The Supreme Court may tender or may refuse to tender its opinion to the President on any dispute arising out of any pre-constitution treaty or other similar instruments. This is also wrong. ये उल्टा है. Yeah, this should have been here in terms of Supreme Court must tender its opinion if it is related to pre-constitutional treaty, and this should be there that may refuse also. So first two statements are wrong. In both the cases, opinion expressed by the Supreme Court is only advisory and not a judicial pronouncement. Only three is the answer, right? So we'll do individual statements, and accordingly we should be able to come to the answer. So you will think, or you will do it individually instead of coming to the answer. You should be sure of every statement. ठीक है? So not showing you the statements. Now, judicial review is the power of the judiciary to examine the constitutionality of legislative enactments and executive orders of both the central and the state government. Power of the judiciary to examine the constitutionality. ठीक है. So first statement right है. Second statement देखेंगे. India is the only democracy in the world to have concept of judicial review. Now this statement that India is the only democracy, now this statement itself is wrong, because judicial review is there in many countries. Why the statement is put, I am not even sure. So ये सही है, ये गलत है. Judicial review is considered as a basic feature of the constitution. Yes, ये भी सही है. So we've got 2 is out. ठीक है. So 2 is out, 3 is right, 1 is right. Which of the following statements correct about judicial activism? ठीक है. The concept of judicial activism originated and developed in US. And the answer is yes. The concept of judicial activism originated and developed in US. सही है. Next, judicial activism denotes the proactive role played by the judiciary. Judicial activism denotes the proactive role played by the judiciary in the protection of rights of citizens and in promotion of justice in the society. So first statement is right. What do you think? Is second statement also right? That is, judicial activism denotes the proactive role played by the judiciary in the protection of rights of citizens and in the promotion of justice in the society. And the answer is yes. A series of judgments, popularly known as the first judge case, second judge case, and the third judge case, is most closely related to. So, judicial accountability, citizenship, parliament's power to amend the constitution, judicial appointments. Clear cut. D. No confusion at all. Now, ठीक है. Try to attempt it. Which of the following provisions are to ensure the independent and impartial functioning of the Supreme Court? So you've got security of tenure of judges. ठीक है. Try to think even articles. If you can think of an article, then you may come to a point that okay, it is there or not, and does it help the judiciary to function autonomously or independent? So you've got security of tenure of judges, expenses charged on CFI, consolidated fund, conduct of judges normally cannot be discussed by parliament, ban on practice after retirement. So you've got 1, 2, 3, 4. All are actually right. Security of tenure of judges, 124 clause, basically 4. Proved misbehavior and incapacity. Without that, a person could not be removed. Expenses charged on consolidated fund, Article 146. Conduct of judges normally cannot be discussed by Parliament, Article 121. Ban on practice after retirement, that is 124 clause 7. When there is lack of quorum, अच्छा question is with reference to ad hoc judges. ठीक है, ad hoc judges पे सवाल है. So when there is lack of quorum, the quorum of the permanent judges to hold or continue any session of Supreme Court, the President can appoint ad hoc judge. Now another is he enjoys all jurisdiction, powers and privilege of the Supreme Court. What do you think? First statement, second statement, both right, both wrong. What is the context? Enjoys all jurisdiction, power and privilege of the judge of Supreme Court. Chalo, second is right. What do you think about the first one? See, just to show you, I had told you about 3 articles that you need to look into: 223, 224, 224 capital A. So talk about 223 acting Chief Justice. The question is not on acting Chief Justice. Question of additional and acting judge. Okay. So if we talk about the 224 appointment of additional acting judge, if the reason of any temporary increase of business of High Court, it appears to the President that the number of the judges of the High Court should be, you will find here the NJAC would be written, but NJAC is not in the picture. No person appointed as additional judge of High Court shall. This was a question altogether. Now you already know it. So the point is, to get the answer of this question, you should know it. For Supreme Court, it is not 223, 224, 224A. For Supreme Court, it is 127. Yes. So if I was showing you the 223, it should have clicked you that why. The question is why we are looking at 223, 224. We should have gone to 126. And you will notice that, because that is where you understand that where we are going wrong. Though we know that 223 also you should know, 224 also you should know. Because you may not find ad hoc in High Court. If at any time there should not be a quorum of judges of Supreme Court, you will notice that it is actually the Chief Justice would do it. Here it is written that the President would do it. That is where the difference is. So it is not done by the President but the Chief Justice. If you got it right, it means you know your basics. Next is, consider the following statement. The minimum age prescribed by the Constitution for appointment of a judge is 35. He holds office until he attains the age of 70. A person appointed as a judge has to take oath before the Chief Justice. So what do we find? Answer is all three. 1, 2, 3. So answer is 1, 2, 3. Why all three? Because we need to pick up not correct. Incorrect statement needs to be picked up. So all three. Now, which of the following statement is correct about PIL? Now, we've got provisions of PIL was introduced by 44th Constitutional Amendment. What do you think? Was it introduced through 44th? Neither is. Or could it be 42? So think 42 or 44th. And second statement is it can be filed both in Supreme Court and the High Court. So the second statement it can be filed in both Supreme Court and High Court. This statement is right. So two right hai. First statement, provision of PIL was introduced by 44th Constitutional Amendment. Now in this context what we find is this was not introduced by any amendment. We've seen that in context of the introduction of PIL, if you notice judicial activism, you need to find out the information where we have mentioned it. Look into the judicial activism page. In that, evolutionary view is one of the concept. There you will find it. So it has come by judicial innovation and not by any amendment. Now, try to attempt it. Consider the following statement regarding scope of PIL. The petitions against police for refusing to register a case comes under PIL. Service matter and those pertaining to pension and gratuity. entertained as PIL. Complaint against central government in matter of family pension comes under PIL. And lastly is petition for early hearing of cases pending in High Court and subordinate courts are entertained as PIL. Try कीजिए, ये कोशिश कीजिए. This is a nice question in terms of the understanding. You've got what? Try to look at it. What do you think? क्या होगा बेटा इसका? कोशिश करो. This is a nice question. See, in terms of the petition against police for refusing to register a case comes under PIL. Yes, if police refuses to file a case, then PIL could be filed against them. That why they are not registering. So this is right. Service matters and those pertaining to pension and gratuity comes entertained as PIL. No, this is not entertained as PIL. ये नहीं है. Complaint against central government in matter of family pension comes under PIL. Yes. Family pension comes under PIL. So service matter and those pertaining to pension not entertained, but family pension, yes. So this is there, yes, this is there, yes, this is no. Last is petition for early hearing of cases pending in High Court and subordinate courts are entertained as PIL. And the last statement is wrong. If people keep on filing the cases that hear my case, then the Supreme Court or High Court would be overburdened and everybody would come as that hear my case, hear my case, hear my case. So answer is 1 and 3. Now, with reference to the Supreme Court, which of the following statements are correct? The judges of Supreme Court are appointed by the President. The number of Supreme Court judges are increased by the President. As per the Constitution, only the senior most judge of the Supreme Court can become CJI. So you will find that the judge of Supreme Court are appointed by the President. सही है. Number of judges of Supreme Court are increased by the Parliament. ठीक है, तो यहाँ President है, यहाँ Parliament आएगा. As per the Constitution, only the senior most judge of Supreme Court can become CJ. As per the Constitution, only the senior most judge of the Supreme Court can become the Chief Justice of India. In this context, we find that ये गलत statement है because it is not as per Constitution, this is as per Convention. ठीक है? In which case did the Supreme Court pronounce the judgment for the first time that basic structure of the Constitution cannot be amended by Parliament? Clear cut. Case Savananda Bharti case. No issue in this. Which one of the following statement is correct? The Constitution clearly lays down what its basic structure is. The Supreme Court has elaborately defined the basic structure of the Constitution. Neither the Supreme Court nor the Parliament have defined the basic structure of the Constitution. D is all of the above. Neither the Supreme Court nor the Parliament have defined the basic structure of the Constitution. This is the right statement. Now, which of the following comes under the exclusive jurisdiction of Supreme Court? We've got dispute between center and state. the writ jurisdiction, pre-constitutional treaty, election of the president. देखिए सेंटर एंड स्टेट दैट इज देयर clear cut है article. This is now not necessarily article 131, but 131 is there in this context. So one is right, two is wrong, because High Court also has a writ jurisdiction. So one is right, two is wrong. Three, if at all you get confused, let's say a dispute arising out of pre-constitutional treaty, I'm just saying that if at all you are getting confused, then even if you look at the fourth point, dispute related to election of the president, and we've done that, the dispute related to election of the president 71 कॉन्टेक्स्ट में आप चेक कर सकते हैं एक बार इलेक्शन ऑफ द प्रेसिडेंट एंड वाइस प्रेसिडेंट की उसमें चैलेंज में matters relating to or connected with the election of president or vice president. It is clear that all doubts related to election of the president shall be decided by Supreme Court. So, the statement that is fourth is right. Three हमने किया तो हुआ है. We've done three also, that pre-constitutional treaty पे you don't have exclusive jurisdiction. So we have 1 and 4. Now, next. A citizen of India with which of the following qualification can be appointed as judge of Supreme Court? ठीक है. Citizen of India with ठीक है. So somebody who could be, who is eligible to become the Supreme Court judge. ठीक है. Judge of a High Court for 5 years. Judge of a High Court for 5 years. Distinguished jurist in the opinion of the President. The advocate of High Court for 10 years. ठीक है. So you find that all three. ठीक है. All three would be coming into this. ठीक है. With respect to Supreme Court of India, at present Supreme Court has provision of 34 judges excluding the Chief Justice. Second is the Parliament can increase the number of puisne judges in the court by passing a bill by simple majority. So first statement though itself is pretty clear that Supreme Court has provision of 33 plus 1 or 34 judges including Chief Justice. So first statement is wrong. Now second statement, the Parliament can increase the number of puisne judges by passing a bill to the effect of simple majority, and you will find yes, these amendments are not deemed to be amendment under 368. So number of judges जो increase होते हैं, right? If you look at the article 124 clause 1, देखिए, let me show you. ठीक है, we find that there shall be Supreme Court of India, and until Parliament by law prescribes not more than 7 other judges. ठीक है, that we had seen that not more than 7 judges. So 7 was there. We have 7 other judges, that is CJI plus 7. So there were total 8 judges, right? 124 clause 1, we had seen that. So this is wrong, but means number 33 plus 1 or 34, and this is yes, simple majority say they can actually pass it. Now, until the Parliament provides otherwise, for which of the following purpose only English is to be used? Acha. Okay, good. So, until the Parliament provides otherwise, for which of the following purpose only English is to be used? So, we've got all proceedings in Supreme Court. We've got all proceedings in every High Court. Then, the authoritative text of all ordinance. Then, text of all orders made by district collectors. All these things. Now, देखिए, there could be a position where you may not have done or you may not know the answer. वैसे, just to give you an idea, it is seen, एक minute, language is, एक minute, see, official language 343. This is what the context is, Article 343. So 343 to 351 language is there. 343 to 351. I might have told you earlier. However, again, to give you an idea, language 343, 44 again language. So, not going into the domain of every single, let's say, article, because I had shown you all these things in terms of language. So, 343 to 351, everything is related to language. If at all there is a confusion, just have a read, go through that. Now, even if we do not know the answer, जैसे, let's say I'll show you the option. I'm not sure how the options are placed. Now, it says that until the Parliament otherwise provides, which of the following purpose, let's say only English is supposed to be used. Now, one of the thing is text of all orders made by the district collector. So, 4 is out. District collector. Why would the DC be asked to give, let's say, orders or orders of the DC should be there in the local language? Why? It could be in English also, but why all orders means the DM could give certain orders in English, but it cannot be that you need to give it in English. So 4 has to go. Now, in terms of 4, you are sure that 4 is not there. Now, you are left with 3. Now, if you are not sure about the other statements, you will not go ahead. You will leave this question. But we are able to remove 4. Right? Bengal में the DC would maybe give the information in Bengali. Now, when you talk about first statement, all proceedings in Supreme Court. So yes, you will have people from different places. We've got so many languages. So if we say that no, a people would or Supreme Court language would be in or would be also having Marathi, Telugu, Tamil, Kannada, so there would be problem. So there has to have that there needs to be a single language at least in the until unless the Parliament otherwise provides. So if got 4 is not there, 1 is surely there. So we were able to remove 4. We were able to remove second because here the first option is not there. We are only left with now 2. 2. You will 100% now attempt this question, because you are sure these 2 cannot be there, and now you are sure only one of the option is right. Now, second option is here, all proceedings in every High Court. So, at least this is there, right? So, only 3 needs to be identified. The authoritative text of all ordinances. So, when we talk about the state, ordinances are basically laws, and agreed, it follows different procedure, and we've seen Article 123 in terms of the President and 213 in context of the Governor. So, the authoritative text of all ordinances are actually supposed to be given in English. because you're talking about the whole state, and whole state may also not have a single language. In this context, if Parliament by law provides otherwise, so Parliament has provided, so we do have ordinances in other languages also, but so 1, 2, 3 has to be the answer. I'm saying that even if you're not sure about the third point, but if you come to this point that only out of these two is supposed to be an answer, you will tick it. ठीक है? We've got consider the following statement regarding removal of Supreme Court judges. ठीक है? In case of Lok Sabha, a removal motion must be signed by at least 100 members. So, removal of Supreme Court judge. The committee for the removal of Supreme Court judge consists of Chief Justice of High Court also. Now, here we are talking about removal of Supreme Court judges. You know it that in the class we had done that the procedure for removal is not mentioned. Means it is said that it would be removed by the President as per Article 124 Clause 4, that the motion needs to be passed by both the houses, special majority, and it will be removed by the President would stamp it, so person is removed. But exactly how the procedure to prove misbehavior or incapacity, because the grounds are only proved misbehavior or incapacity. For that, we had seen that Article 124 Clause 5 talks about that a law could be made. So a law was made, that is Judges Inquiry Act. We had seen that. So under that, you will find it is clearly there. If you want it in Rajya Sabha, then 50. If you want it in Lok Sabha, 100. Now this is clear. Now the second is the committee for the removal of Supreme Court judges consists of Chief Justice of High Court. Now you think that you are talking about removal of Supreme Court judge. Here it is written that Chief Justice of High Court is also there. So could a Chief Justice of High Court be there for the removal of Supreme Court judge? Think on this line. And it may seem a bit odd that how could the High Court Chief Justice sit at the time of the removal of Supreme Court judge. However, in Judges Inquiry Act, this is how it is there. You will have a Supreme Court judge, means the Chief Justice of India or the Senior Most Supreme Court judge you may have. You may also have a Chief Justice of a High Court and a distinguished jurist. 3-member committee was set up. We had even clearly mentioned that. So don't get confused. And also why it was added, because the same procedure is there for the removal of High Court judge. So you will have the same committee. You may not have the same member, but composition would be same. ठीक है? तो दोनों. Now this. This to we had seen. ये तो similar form of question is there. We are not going ahead with this question. With reference to the appeal by special leave, consider the following statements. It can be granted against any court or tribunal except a military court. Second is, it can be granted in any judgment, whether final, interlocutory. Okay. Now, when we see appeal by special leave or special leave petition, we know that we are talking about Article 136. It can be granted against any court or tribunal except a military court. So, first statement is right. It can be granted in any judgment, whether final or interlocutory, and the second statement is also right. Now, which of the following acts have been forwarded by President to the Supreme Court? Okay, this is question related to Presidential reference case, that is 143. In context of 143, we find that Kaveri Water Dispute Tribunal 1992, Berubari Union 1960, 42nd Constitutional Amendment 1976. I had clearly told you, you will look into the cases. There are not many cases, 14, 15 odd cases are there. You will not mark up all cases, however, you will go through all the cases in terms of names and you will mark up few. So with that, what we can easily do is, we know that 42nd Constitutional Amendment 1976 was not a presidential reference case. We did not send this amendment to the Supreme Court. So third is out. So you will be left only with one option. That's Kaveri Water Dispute Tribunal and Berubari Union. So we are sure with Berubari Union. This, at the time of the starting of the class, when we had started, I told you that Berubari Union, lot of time is written as Re Berubari. So that's presidential reference case. So we were sure about second also. However, with that, we were not able to come to the point. But with this, we are, once we know it for sure it's not there, with the reduction method, we can do that. There is some issue, but some mixed question has been mixed. So not going to this. Following statement with regard to PIL. So we've got in India Justice P.R. Krishna Iyer and Justice P.N. Bhagwati were the pioneers of the concept of PIL. PIL facilitates the effective access to justice to the social and economically weaker section. Okay. Now in this context, what do you think is the answer? And you will notice that we've got this is a right statement, this is also a right statement. Judicial activism में you will notice we had even written the name also. ये लिखा हुआ था हम लोगों ने P.N. Bhagwati, Krishna Iyer, Chandrachud, we had written that. Next is the power of judiciary to question the wisdom of the laws enacted by legislature. The power of the judiciary to pronounce upon the constitutionality of laws and executive orders. The power of the judiciary to review all the legislative enactments before they are assented to by the president. The power of the judiciary to review its own judgments given earlier in similar or different cases. So you will find that constitutionality of laws and executive orders, यही context में जाएगा. There shouldn't be any confusion. The Constitution declares Delhi as the seat of Supreme Court. So think about Article 130. Does Article 130 says that seat of Supreme Court should be in Delhi? And the next is the Constitution authorizes the Chief Justice of India to appoint other place or places as seats of Supreme Court. And you will find that both the statements are right. ये दोनों. This 130. Look at Article 130. Basic structure. This we have already seen. 143 we have seen. Now this is a nice question. In terms of this question, we find that, see, ये question try कीजिए, मतलब this is actually a nice question. The statement says the territorial jurisdiction of Supreme Court for issuing writs is wider than that of High Court. Second statement is saying the Supreme Court may not refuse to exercise its writ jurisdiction, right? So first statement, a lot of you may think that uh, first statement is wrong. However, the first statement is right because it is talking about territorial jurisdiction. It is not talking about writ jurisdiction only, it is talking about territorial jurisdiction in terms of writs. Territory, Supreme Court's writ jurisdiction territory is the whole of India. However, for High Court, it is only the state. That does not mean the High Court cannot issue writs for outside the state, but that event should have taken place within the state. So there is a difference. इसलिए this statement is actually right. So this is actually a good statement. ठीक है? Supreme Court may not refuse to exercise its writ jurisdiction. Yes, it is related to fundamental rights. Supreme Court Article 32 is related to the FR. So Supreme Court would not excuse or would not refuse to hear a question related to fundamental right. Now, the judges of the Supreme Court are appointed by the appointment committee of the cabinet. Next is Supreme Court has exclusive original jurisdiction in interstate water dispute. So, first statement is wrong. Second statement is wrong. So, answer is C, both 1 and 2, because question says are incorrect. And that's what we have it. So, we've done the whole judiciary. It has been revised again. So, if you could answer all right, and I know a lot of you got all the answers right, it means you have done it very well. However, if there were certain questions which you could not do that well, with revision you would be able to do that. Now you can let me know which area would you like to do in terms of questions, or I'll pick up a random question now because we've got only Parliament and PRIs which is left. So heading is Parliament. Heading लिखिए बेटा Parliament. It don't continue with the on the same page. Go on to another page. ठीक है, अलग page में, different page पे लिखिए. So this is the biggest topic which is left. It should take us 1, 2, 3. Yes, maybe by day after we should be able to finish it up, and then PRI. So it should be today because we've got almost 2.5 hours of class left. 8 hours, 10. ठीक है, so we should be able to wind up maybe by then let's say within the next 3 to 4 days. Okay, so we've got only Parliament and we've got only PRIs. That is what is left for the polity class. Okay, now let's see a question. Sir, Article 21A and 51AK also match or similar. Can we also use this article? ठीक है बेटा, वो 21 capital A, that is a fundamental right, and a duty, that is the guardian or the parent should be given an opportunity. That's a good linkage beta, good. So we've done a good linkage, though I had told you about this that it happened together. So there, through that also logic, if you are applying it, still good, otherwise also it is still good. So that's how you are able to, or I have given you these approach, but you could actually link it to that level. That's actually very good. ठीक है, और good beta, अच्छा हुआ. ठीक है. Now, in terms of Parliament, देखिए, Parliament would have many things which are in general pure factual, where concepts are not there. I would explain you, but we would not be writing it. There are many things where a lot of concepts are there, and it's not written in the text also. So we would go in terms of discussion as well as writing. For that, we would do both the things. Okay? So make sure that once you go back home also, you finish the Parliament topic, so that once you raise the question, we would sort it out in the class itself. Okay? Now we've got Parliament. In terms of Parliament, we've got lower house, we've got upper house. You have the president, you have the Raj Sabha, you have the Lok Sabha. Okay? Now this is what CB say, it is Parliament. So president is part of the Parliament. However, president is not a member of the Parliament. Okay? So don't make this mistake of thinking that president is not part of the parliament. President is part of the parliament. President is not a head. अगर आ जाएगा कि president is head of the parliament. No. President is also not head of the parliament, because the president does not tell or is not telling the parliament how to function. Or it's not telling. President can send a message to Lok Sabha. President can send message to Rajya Sabha also. The president can say, please means behave in the manner as per the constitution. In as per the message. मतलब वो भेज तो सकते हैं. However, president is not a head. So if at all the statement is coming, president is the head, no, president is not a head. Like governor is also not a superintending officer of the legislative assembly. Now, president assent is required, no doubt, for a bill to become an act. तो लगता तो है, but president, this is a procedure work. But he does not control the behavior of both the houses. So when you are a head, you should be able to control the behavior also. He does not control the behavior, so cannot say that he is the head. I hope you got the point when I say he is not the head. There are different terms which are used for Lok Sabha in different part of the country. I mean, not different part of the country, different part of the world, and even in India. जैसे we've got lower house, that's Lok Sabha. We've got Lok Sabha, that is Lok Sabha itself. We've got popular chamber, that is also Lok Sabha. Why popular chamber? Because they are directly elected. So popularly elected. They are popular, that's why they got elected, right? So you find that different terminologies are used in terms of, even House of Representatives are used in US, House of Common in England. Likewise for Rajya Sabha, different words are used. Upper house is used. Representative of the states, Senate, House of Lords, House of Elders, House with Wisdom. Means there are many terminologies which are used. So I would tell you, you write it down so that if at all a statement or maybe something is coming in news, you should be able to comprehend that they are actually talking about their Rajya Sabha or they are talking about their Lok Sabha, right? Heading is Parliament. So you write down, एक लिखिए lower house, lower house, सामने लिखिए लोक सभा, सामने लिखिए लोक सभा, हाउस ऑफ रिप्रेजेंटेटिव, हाउस ऑफ रिप्रेजेंटेटिव, you've got House of Common, House of Common, popular chamber, popular chamber. ठीक है. Next is upper house, upper house. Write down Rajya Sabha, Rajya Sabha, comma Council of States, Council of States, comma Senate, Senate, comma House of Lords, House of Lords, comma House of Elders, House of Elders, comma House with Wisdom, House with Wisdom. Next line, write the next line. In 1954, Rajya Sabha and Lok Sabha names, in 1954, Rajya Sabha and Lok Sabha names were adopted. In 1954, Rajya Sabha and Lok Sabha names were adopted. ठीक है. So earlier they were called as Rajya Sabha, Lok Sabha, but it was not formally adopted. So it was adopted. So you'll find House of People. that would be used for Lok Sabha. But as term of Lok Sabha, it was adopted in 1954. ठीक है? Write down next line पे लिखिए. Write down. President is not a member. President is not a member of any of the house and does not sit or participate and does not sit and participate in deliberations of any house ठीक है. We know that in Lok Sabha election is direct and in Rajya Sabha election is indirect. Earlier also I had made you understand. However, before we start again, Rajya Sabha we have member of parliament. They go to Lok Sabha also, they go to Rajya Sabha. But the MPs which are going to the Lok Sabha, that is direct election. We find that 2024 you will have Lok Sabha election. MPs who are going indirect, they are to Rajya Sabha. So direct Lok Sabha, indirect to Rajya Sabha. Indirect कैसे? State legislative assemblies are conducting their own election, means they don't conduct their own election. This is election commission is looking into this, but every assembly would have the election and finally they'll be going to Rajya Sabha. That does not mean the people who are contesting for Rajya Sabha they are MLA. No, it does not happen like that. State legislative assembly they do election and they will send the name ahead. जो जीतेगा उसका नाम आगे जाएगा, means the person would win. The person, they can send me also, they can send any of you also, if at all. Not you all, because the age most probably, see, because Rajya Sabha age is pretty high, that's 30. Lok Sabha is 25. So if you are 30 plus, then yes, they could send the recommendation. However, if you are already a government servant, then you cannot go, because a person who is holding office of profit cannot go. What is the office of profit? That is Sarkari Naukri in general. However, as per discussion, we would separately discuss, means at the time of parliament only, we would be discussing all these things. Okay? I hope there is no confusion. Okay? Now, heading is Rajya Sabha. Give a heading as Rajya Sabha. Now, in terms of Rajya Sabha, it's not that when we discuss Rajya Sabha, everything related to Rajya Sabha would be completed here itself. We need to know something about Rajya Sabha, then we'll go ahead. So something, again Rajya Sabha would come into the picture. We would also discuss Lok Sabha, Rajya Sabha, things would come in between. So don't think everything related to Rajya Sabha is discussed here itself. But once we look into the Rajya Sabha, we find indirect election hota. There are few things, basic aspect, not going to that domain, which I have already told you. Indirect election hoga, state legislative assembly, they'll send proportional representation, single transferable vote. That is how the people would be sent. But the point is, what we need to see is, there are certain people who are also nominated. ठीक है? आप ये देखेंगे राज्य सभा की strength. Is it 245 or is it 250? This you will see. Is it that 250 is the maximum strength and currently 245 are there? You will check that. ठीक है? ये देखिएगा, so that later on you don't have confusion. Don't think these numbers are vacant in the sense currently elections were not conducted, that's the reason the gap is there. No, not necessarily. Vacancy would come, इसके अंदर vacancy आएगी. Okay, so I'm saying you will look into these numbers. Secondly, you will also look into the numbers states and UTs, because ये जो states हैं, this division 250, 245, ये all these numbers are divided into states and union territories पे ये numbers divide होते हैं. तो you have to have this understanding that J&K was earlier a state, now has become a UT. So there are a lot of textbooks, even online sources, which have given the wrong information, because state में जो context है, as because J&K once it shifts to and becomes a UT, so the seats which were there with J&K for Rajya Sabha, now that has been shifted to the a union territory, right? So numbers pe be careful. You may expect question from this side. I'm telling you where you have to concentrate. Take care. In terms of nomination, we find 12, 12 experts are nominated. Okay, 12 experts are nominated. So write down. President nominates 12. President nominates 12 members having, ये basically ठीक है, president nominates 12 comma इतना कर लो comma having special knowledge, having special knowledge or special knowledge or practical experience or practical experience in literature, in literature comma science comma science comma art, art, literature, science, art, comma social surveys. Now, so there are 4 categories under which the president nominates. Don't make a mistake. There is no category like sports. Something like this is not there. Sometimes people get confused because Sachin Tendulkar was nominated to Rajya Sabha. This is not a category. He was nominated because sport is an art. ठीक है? Also, in terms of governor, governor has one extra category. So governor is able to nominate people from not 4 but 5 category. President is able to nominate from 4 categories. So look into that category which is exclusive to the governor but not to the president, or which is more with the governor and not with the president. ठीक है, ये बहुत ध्यान की ज़रूरत है, because this could be asked in PT. At the time of the governor also I had told you that you need to look into these domains, because if at all a question comes in, it would be too factually easy question. Never, you should not lose any marks. However, something of this similar, something which is so obvious, that's not right, right? Now, see, there was a fight in terms of fight. When I say there was a disagreement, the issue related to indirect election, there was a lot of discussion. However, for nomination or nominated member, the issue was, let's say, discussion went ahead where there were many heated discussions. Why? Because nomination fundamentally mars the elected or election procedure, right? So democracy needs to have election. So there was an issue saying that we should not have this nomination of members. But finally, the nomination or nominated members issue prevailed, because the experts who could never come to Rajya Sabha without election, with election, there are people who cannot contest election. Literally, election requires different kind of energy, different kind of approach. There could be experts in different domains. We would like to have those experts in Rajya Sabha to better the laws. That's the reason we've got, we call Rajya Sabha as house with wisdom. Sorry. So why do we call it? Because we've got more experts. So there was an issue, but this issue did not prevail. Write down on the next line. Next line में लिखिए nominated member issue. Write down nominated member issue. Write down objections were taken. Objections were taken in the Constituent Assembly. In the Constituent Assembly in regards to nominated members, in regards to nominated members, as it fundamentally mars as it fundamentally mars the principle of election, as it fundamentally mars the principle of election. Full stop, continue. Also the presidential nominations might have favoritism. Next line. The objection did not prevail. And the principle of nominated members were adopted with a view to give representation to certain non-political interest which might not otherwise get any representation in parliament. Next line. While nominating, the President acts on aid and advice. The President acts on aid and advice of Council of Minister, and the courts do not interfere. Here. Right. Give a gap of 1 2 line. After 1 2 line, write down. It is a permanent body. Permanent means Rajya Sabha लिख लो ऐसे. Rajya Sabha is a permanent body, comma, one third of its members retire every second year. Always look into this 1/3 ko kahin they don't make it 2/3. So always concentrate here also. 1/3 of the members retire every second year. Within the bracket, write down Vice President acts as ex officio chairperson. Vice President acts as ex officio chairperson. Next line. put a star mark, any elector from any part of India, any elector from any part of India is qualified is qualified is qualified to be elected from is qualified to be elected from any state, from any state. Underline कर लो, any state. Full stop, continue. Until 2003, as per RPA 1951, representative of the state or UT must be an elector from a parliamentary constituency, Now what does this mean, right? Now let's say this is a state. Now country badi hai, right? Now earlier a person who is supposed to be sent from this place from this state had to be an elector somewhere here. But इसको और देखो, let's say name wise कर लेते हैं, it will be easier. Somebody who needs to be sent to Rajya Sabha from West Bengal. Earlier was that he was supposed to be from, let's say, or he was supposed to be an elector in West Bengal. Does not mean that the person is having Bengali origin or not. If I go and shift my voter ID card to West Bengal, I would also become eligible. Earlier, this is what the case was, or this was the case. So people who are having their electors, or let's say their electors in West Bengal, could be sent from West Bengal to Rajya Sabha. However, this provision was removed in 2003. So today, if I am not, let's say, an elector in West Bengal, I could be an elector in UP, I could be an elector in Kanyakumari, or maybe Tamil Nadu, Jharkhand, Chhattisgarh, I am still eligible to be sent to Rajya Sabha from West Bengal. जैसे Manmohan Singh Saab was being sent to Rajya Sabha from Assam. He was not an elector from Assam, but he was being sent. So make sure, don't make mistake. Rajya Sabha, a person to be sent to Rajya Sabha from a state does not necessarily need to be from that state. Person could be from any place. Okay? Until 2003, this was a criteria, but now it is not there anymore. Okay? Now, sir, something people nominated, sometimes from law background, Justice Gogoi, and also economic background might be Ashok Lahiri. Which category they fall? बेटा कुछ भी हो सकता है. It भाई you know literature है, science है, social service है, right? Art है. So it could be anything. They could be taken. See, for us, it's not important that they were taken from the category. It could be social service. Social service does not mean NGO only, right? So service towards the society. So while serving in the organization also, people do give service. They've served the society. So that's part of social service. So you should not worry under which category a person was made. To give you an example for Sachin Tendulkar, that was that how could he become the, let's say, you should not memorize that he actually got it from art, but to counter that, how come he also came into the picture and when sports is not a category. That is what I wanted to clarify. Never look into under which category a person is going. You know these 4 categories, that's more than enough for the exam. ठीक है बेटा? We would continue after the break बेटा. We'll continue. ठीक है? चलिए मिलते हैं 1 घंटे बाद.